And our today's topic is the first results of selection of new judges or justices of the Constitutional Court of Ukraine. And among the panelists today are Ms. Victoria Ptashnyk, MP, Yulia Kyrychenko, the constitutional law expert of the Center of Political and Legal Reform, Mr. Miskyy, who is the director of advocacy section of Reanimation Package of Reforms, and Mr. Bondarenko, the Center for Political and Legal Reforms. Well, we debate today the constitutional court composition, and when Ukraine's constitution was debated, yet at that time, we fixed the norm of selection of the justices of the Constitutional Court of Ukraine. So now we live through a competition among contests of the people who put their candidacies forward, claiming the positions of the justices of the Constitutional Court. And I wanted to say that, unfortunately, we cannot see a transparent and fair process yet. The process we meant when we discussed the draft of the law on Constitutional Court, when that bill was debated, because the bill that was introduced by the Committee on Law and Justice, it practically allowed political appointments rather than real selection, or election process, with adherence to all the norms of professional ethics and professionalism and so on. The provisions of the law on Verkhovna Rada of Ukraine fixed this right of the MPs to put forward their candidacies, to propose their candidacies for the positions of the members of Constitutional Court. And regrettably, this bill, this act practically, when it was yet introduced, it didn't include the norms necessary for this transparent and fair election. So this contest is being supervised by the committee, previously mentioned Judiciary Committee of the Parliament. And this committee also plays the role of a contest committee that was supposed to be established, according even to that bill, that to that act that was adopted regarding the election of the Constitutional Court justices. If we compare the situation or the procedure rather, with the procedure that with that of the election of the justices of the Supreme Court of the country, if we compare it with the contest for the positions of the Constitutional Court justices, we can see that in Verkhovna Rada they don't hold online broadcast. There are no, so to say, dossiers, no information about these judges published. And as we now know, only the candidates who practically were adopted, so to say, by specific parliamentary fractions were allowed to participate in the contest. One might assume that there were certain arrangements reached among them, or between them rather, and we all, as the members of parliament, practically lost our right, this option of choosing the candidates of our liking, those people whom we consider to be corresponding to the norms of ethics and professionalism and so on. As we understand that it's not yet too late to return to that procedure, restore that procedure envisaged for the election of the justices of the Constitutional Court. We think that we need to make a number of steps in order to elect the judges who will not will not bow to the pressure of specific parliamentary fractions. The Euro-Optimist organization they earlier today issued their own statement about, namely, the need to restore the fair and transparent procedure. Their demand is that all the candidates who submitted their documents for that contest, that they all be reviewed, and the norms of that and parameters of that contest, as envisaged, by the way, also by the Venice Commission, they should be adhered to. Therefore, before I turn the floor over to my colleagues, let me once again emphasize that the Constitutional Court's activities should be independent, and the role of the Constitutional Court is not yet fully appreciated. Although, at the same time, a Constitutional Court should become closer to the people. And certainly that norm enabling any citizen of the country present or submit, rather, their requests to Constitutional Court should be adopted, should be approved, so that everybody can prevent, or at least exert some efforts in order to prevent the adoption of unconstitutional laws and their application. Therefore, I hope very much that my colleagues will join the Euro-Optimists on the grounds of their statement, and this contest will be further on conducted in a transparent manner, in a fair manner, with all the norms that are needed be provided, be adhered to. I'm Yulia Kyrychenko. I'm a representative of the Center of Political and Legal Reforms. It's a non-profit, non-governmental center. We have been, for the last 20 years, involved in various efforts to improve the constitutional structure, so to say, of Ukraine. And in this particular instance, when we see a flagrant violation of the norms providing or guaranteeing the independence of the judiciary are violated, we cannot stay silent. We all remember that recently the constitution of Ukraine was amended, was changed significantly in a very unlawful way. Today we have the situation with the Constitutional Court specifically, that can be characterized as the inability of the Constitutional Court to point to any other branch of power to illegality or unlawfulness, rather, of their actions. So this contradiction to constitutional structure has rather become typical in the recent years for all branches and all hierarchy of Ukrainian authorities and government. We see this mechanism of election of the judges as a mechanism to protect basically our rights, and we think that for the next at least 9 years, this composition of Constitutional Court that is being decided today if it's not done properly, I can guarantee you 90% that there will be politically motivated decisions by Constitutional Court. Let me remind you that we now have 14 justices already selected or elected. And by the new version of the Act, or Constitutional Court Act, this contest is practically considered done, completed, but in reality, let me assure you that there has been no contest. For example, if we would like to see a justice of Constitutional Court elected as a result of that contest, we see no candidates who have underwent practically this contest according to the norms that we considered necessary. When constitutional reform was done, you remember that there were 300 votes in favor of constitutional reform. At that time, also, we may say that a number of new principles guaranteeing the independence of Constitutional Court were introduced. And I would like to thank the other deputies that they draw the public's attention to the fact that that decision, adopted by 300 votes of Ukrainian MPs, has been or is being now breached and we may say destroyed. I have no words to describe the situation. It's in no country could it happen so that a person just for his or her loyalty to a parliamentary fraction is practically appointed a member of that country's constitutional court. If that person was especially, or had been before that appointment, we need to call it selection, but if that person especially was a member of that or the other parliamentary fraction, that has become a facilitator. And we have analyzed 7 candidates who all agreed to participate in the contest. 3 of them were not allowed to take part in that contest by the parliamentary committee, by the on the judiciary and on law and justice committee. So we hope that at least those 7 candidates should be allowed to become become members of the discussion with the rest of the MPs, probably in the plenary session of the parliament. Especially important are two important, particularly important principles: the high professional level of a lawyer, and then high professional ethics. When we attended the meetings of the Committee on Law and Justice itself, we didn't see any contest, and we were informed on the same day that there will be some discussion of that. But literally next day, the information about the election of the 2 candidates who were supposed to be there on the day we were there, it was published on the website of the Parliament, on that committee's web page. So we would invite the other NGOs to get involved in this discussion and make all they can, make their best to prevent Ukraine drifting towards authoritarianism, towards dictatorship. Thank you, Yulia. We have been very thorough in observing this process of the judges of the top courts of the country, and there is a new version, as you have heard, of the law on the Constitutional Court. Unfortunately, in the existing law, there is a provision that I dare say is a bomb, destroying practically the constitutional fabric and the independence of the judiciary. It says that a judge may not be a member of, or shall not be a member of any parliamentary fraction, and a number of other provisions. But here we have the situation when the Verkhovna Rada, on its quota, elects a specific number of justices of Constitutional Court, according to the procedure of the Parliament. Let me ask you, what does the parliamentary procedure has to do with the law on Constitutional Court? We criticize the authors of this Act, Constitutional Court Act, many times for this lack of transparency of this election process, but there has been no reaction yet. In 2003, there was a decision by the Constitutional Court that opened the way for the then president of Ukraine, Mr. Kuchma, to become for the third time a president, to stand the elections for the third time as a violation of the constitution. So we prevented the appearance, the emergence of Ukrainian Mugabe at that time, if you want. But after that situation was prevented, then there was the situation of 2010 when the then president, Mr. Yanukovych, using the Constitutional Court, enhanced his authorities, constitutional authorities, and again, a few years later, what we call with the Arabic word Maidan, that Maidan revolution occurred. So we think that we need to do our best, to prevent the justices of the Constitutional Court to be politically loyal to the incumbent authorities and leaders of the country. But we all remember that a few years ago, for example, the number of justices of the Constitutional Court were awarded, got very high awards from the then president of the country. And last year it happened again with the two justices of the Constitutional Court that are still the members of the Constitutional Court. In 2016, there were two awards were bestowed upon the two justices on the Constitutional Court. So the situation now, or the election process now, is that they meet privately, the candidates and the members of the committee, and they discuss something, they talk about something, and maybe they find some arrangements, but we do not know about that. Maybe they make some decisions in advance before reviewing certain cases. And let me assure that in this case, in this situation, we supported one of the candidates, and that lady was a staffer of the Constitutional Court itself, and she submitted her documents both to the President's administration, to the Verkhovna Rada. She's considered a good specialist in law, and she is quite ethical person. But she was not even allowed to stand in that contest, and as you can see, when people are not even allowed to participate, that's, leaves me lost for words. And let us acknowledge that the Constitutional Court of Ukraine has never been, during all this independence period, has never been really independent. So let us avoid this situation when this lack of legality, this unlawfulness provoke yet another revolution in a couple of years. Let me give the floor now to Mr. Bogdan Bondarenko, who is now even writing his doctoral thesis on on that part of the constitutional law that deals with the election of Constitutional Court members. Well, we have analyzed the candidates who not only presented their candidacies this time, but also previous time. But speaking specifically of these 7 candidates who were the quota of the Verkhovna Rada, and there were 4 of them were actually considered approved by the Law and Justice Committee. But if we speak about all the 7 candidates, we can say that these are different people. That Ms. Denisenko, who was mentioned previously, the staffer of the Constitutional Court, she's a qualified lawyer, and she has a strong academic record. She has been in the Constitutional Court Secretariat for the last 20 years. So she is very well aware of these facts of political engagements, political influences to which the Constitutional Court members were subjected. So her candidacy we analyzed, as well as the other candidacies. The other 2 candidates were Mr. Zaitsev, who also take the position at the Supreme Council of Justice. He couldn't reach a minimal score during during anonymous written test that he was supposed to stand. All the candidates were supposed to stand. And the other lady is a PhD in law. She's from Chernivtsi. She used to be a common court judge. So these were the 3 who couldn't take part in the contest. The other 4 who were approved, they were all with academic background, although none of them specialized in constitutional law. 2 of them failed their tests when they candidated themselves for Supreme Court of Ukraine. But after failing their bids for the Supreme Court, they were selected by the Parliament through the quota of the Verkhovna Rada as the candidates for the Constitutional Court. High moral standards have already been mentioned. We need to bear in mind that these people, the candidates, should have higher than ordinary moral standards because of the fact that their position is very much elevated, so to say, in the whole judiciary hierarchy. The Constitution seemingly prescribes the contest procedure, but it's not clearly defined, neither in the Constitution nor in the law. There are some gaps. So the procedure that we now have as a, so to say, legal procedure prescribed by law, now it does not allow anyone to determine whether a candidate has high moral qualities or not. If a member of the Justice and Law Committee is asked, why do you consider that candidate, or did not consider that candidate being a highly in possession of high moral qualities, their reply might be, you know, very, very, so to say, vague, ambiguous. So these two main criteria as high moral standards and professionalism, in my view, should be also augmented by the third criteria, which is political independence. A candidate should not be a member of, for example, local councils, because during that time they would be, you know, basically the members of the vertical power structure. So this political neutrality criteria should be included into the contest procedure, but it's not in there. And what we are left with is these NGOs like ours, with our attempts to improve this procedure, and that's it. We cannot, we do not foresee any possible steps, rational steps on the part of the Verkhovna Rada on how to improve this procedure. Another issue is that the contest, the deadline for the presentation, for the submission of documents was November the 18th. Today is November the 24th, and we do not yet know who has presented, who has submitted the documents, whose candidacies are going to be reviewed, who are the participants of this election. And then there is the contest commission that is under the President of Ukraine. They are supposed to publish their findings at a certain stage, but as this procedure has not been established clearly, we do not have any fixed terms for publication of for the publication of any information related to this contest. So all the candidates at least all the candidates of whom we are aware, the candidates of the parliamentary quota, they at least should be, those candidacies should be reviewed more thoroughly. And general conclusion is that the procedure, the current procedure for the election of the justices of the Constitutional Court is unconstitutional in itself. Thank you. Thank you. Any questions? Well, I am not sure that after this very detailed review of the situation. There might be any questions, and even more so that there are no constitutional experts among the audience. Maybe the journalists would like to ask any questions, but I'm not sure that they can be knowledgeable enough in order to put any questions. So I can only ask you a question myself. What are the next steps? Well, we are planning to draw the attention of the MPs and maybe of the Speaker of the Parliament and return this whole matter to the Law and Justice Committee for their second review. That will be that next step. So now we are at the stage when we are trying to raise this issue with within this reanimation reform package. At least try to raise it to the level of Speaker of the Verkhovna Rada, and so that this situation is amended, corrected, so to say. I can only add that the Legal Policy and Justice Committee is the only entity in charge, we also call it Justice Committee. This is the only entity in charge of this contest or election process. And it now entirely depends on the committee how the candidates are elected, whether there will be any interviews, will any information be published about those candidates, and each candidate by law is required to file a sort of a dossier, his resume, his autobiography describing his or her background. And so I know that in the other countries, these packages of documents that are compiled before a judge is elected, they might be of 200 or even 300 pages. So that's the situation as we have it today, and it's up to the Parliament and besides the members of the Committee on Law and or Justice and Legal Policies, no other MPs even have clear knowledge, clear understanding of who the candidates are and whether they are worthy of election or not. I understand that some political fractions might be behind one or the other candidate, and they would support them. But again, the question of whether it all is, to what extent does it correspond to the demands of law, to the requirements of law and of Constitution, remains, to be improved, this situation with this correspondence. So the fractions with their candidates is an issue, and then it's the role of the Committee on Legal Policies and Justice. Its role is very important in determining whether the contest has been, correct or not. Well, we know that the justices of the Constitutional Court are appointed or are elected for a period of 9 years. A number of candidates' incumbency expires, ends in 2 years, so there will be another election in 2 years. If we appeal to the MPs, let us say that they need to do their best in order to elect professional, politically independent, or at least neutral members of Constitutional Court, so that the Constitutional Court functions as the real entity guaranteeing the implementation of Constitution. In this triangle, so to say, of the government, the judiciary, and the parliament, ideally they should all be honest vis-à-vis each other. And the role of the presidency is also important here, because we discuss now the future of our political system for the next 9 years. Have there been any reactions from international partners, maybe some international legal structures who usually monitor the situation in Ukraine? Well, there has been none so far, but because this situation is developing right now, and but certainly we are going to inform, for example, our colleagues, our partners in the European Union, and we also informed them already about this lack of respect of the demands of the provisions of the law on Constitutional Court. When would their reaction be expressed? We do not yet know. Maybe they would react after the election is completed. Let's hope that there will be some reaction on that one. So thank you very much, and let us all hope that the situation will develop and will result in some positive, notions for positive outcomes for our country. Thank you for your attention.